All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here so I can mark you down. China Bradley. Ryan Dancer. Christian Grindell. Kirkland Huggins. Randy McElroy. Randy Lee Shane McElroy. Kendrick Mitchell. Nathan Ojeda. Jaime Zarate.
Here.
Leon Baker. Gregory Horton. Royce White. I believe Mr. White's on his way. Samuel Lopez. Robert Bates. Michael Bowman. Michael Dwayne Bowman. Brad Brewer. Wayne Crump. Sean Earl. Sean Clay Earl. Jeremy Estridge. Zachorian Fulbright. Zachorian Jeray Fulbright. Lisa Holdren. Shelby Hood. Ivan Molina Hernandez. I believe that's not set till 9:15, but I would expect that person to be here. Ivan Molina Hernandez. Jacob Myers. Shauna Newton. Jessica Swindoll. Amy Van Treese. Robert Wells. Daniel Wolverton. Benjamin Miles.
Here.
William Hayes. All right. Is there anyone whose name has not been called and you expect to be on the docket today? Yeah, Benjamin Ray Miles, he checked in. So. All right, do we have any attorneys that are ready? Mr. White? Who do you have, Mr. White?
Your Honor, I was retained with Mr. Bradley, China Bradley, yesterday.
All right, this is cause number CR 20-1, State versus China Bradley. Motion to adjudicate set for status on attorney. Court recognizes Mr. White. Mr. White, you want me to reset this for a status hearing on the MTA or?
Yes, sir. Good.
Got either July 17th or July 13th.
If they have an attorney, they'll fill it out.
July 13th, 17th.
Let's see, July, I'm sorry, if I said 17th, I meant July 11th or July 13th.
July 13th.
All right, so what we're going to do is we'll set this for hearing on July 13th, and then I'm going to go ahead and set it for the contested docket also on July 25th. So if there's no resolution on the 13th, then we'll have the contested hearing on the 25th.
Yes, sir.
Where's your client at?
Back there.
Yeah, go ahead and bring her up. Oh, come on up. I thought she was already there. All right. Smiles, I'm sorry, Miss Bradley, we'll see you back on July 13th. Remember, you're still on probation. Okay, just because they filed a motion doesn't relieve you of the obligations that were put in the terms and conditions of your probation, okay? All right, we'll see you back on July 13th. Mr. Perkins, you ready?
Yes, Judge, I've got the same Lopez that for
Mr. Lopez, if you'll come forward. This is cause number CR 23-58. Good morning.
Good morning. This is one judge that we had made this agreement quite a while back, the last time the state papers weren't ready, so there's no PSI.
Okay. All right, Mr. Lopez, please raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand, speak up loudly and clearly for me. Your name is Samuel Lopez, is that correct? Mr. Lopez, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Robert Perkins. Are you pleased with Mr. Perkins and his representation? Do you feel like you've had enough time to talk with him about your case and that you've had all of your legal questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No.
And where your signature appears in this paperwork, are you telling me that that's your true and correct signature and that you only signed once you understood everything that you read?
Yes.
Mr. Perkins, do you believe your client to be competent?
Yes.
And you've explained to him not only his rights as they pertain to this offense, but also the advantages and disadvantages of a deferred adjudication plea? And do you believe that he understands those and that he's entering into this plea intentionally, knowingly, and voluntarily?
Yes, Your Honor.
All right, Mr. Lopez, you are charged by indictment with the offense of evading arrest or detention with a vehicle. That is a third-degree felony, which has a range of punishment of not less than 2 years in prison or more than 10 years in prison, and also carries with it an optional fine not to exceed $10,000. I see the plea agreement in your case is that you would plead guilty to that charge in exchange for the state's recommendation that a finding of guilt be deferred. That means you not be adjudicated, you not be found guilty, but rather you be placed on community supervision for 4 years with fines, court costs, and the DA's office would be resolving a few other cases that you have: reckless driving, unlawful carrying of a weapon, and you would be forfeiting a weapon seized as part of one of those offenses. Is that your understanding of the plea agreement? And that's what you're asking the court to approve? You understand that if the court approves this agreement and you're placed on community supervision, if during your period of community supervision or probation, you violate any of the terms or conditions, the state could file a motion to adjudicate your guilt, could bring you back before the court, could put on evidence before the court in a hearing. And if the court finds that you have violated any of your conditions of probation, the issue is not whether you'll have evaded arrest or detention with a vehicle back on December 4th of 2022. The issue before the court will be, did you violate any of the terms and conditions? If the court finds that you do violate, then the court has a multitude of options, including up to adjudicating you, means convicting you of this offense, revoking your community supervision, and assessing punishment anywhere within that range from the minimum 2 all the way up to the maximum 10. You understand that?
Yes.
All right. Understanding all that, you still wish to go forward? Okay. All right, Mr. Lopez, how do you plead to evading arrest or detention with a vehicle? Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason? Has anyone threatened, forced, or pressured you to plead guilty?
No.
All right, court will accept the defendant's plea of guilt at this time. Mr. Perkins, any objection to the state's evidence?
No.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state, from the defense?
No.
All right, court's going to review the evidence briefly. All right, the court has reviewed the evidence, finds that there is enough evidence to convict Mr. Lopez of this offense. The court will follow the plea agreement, the recommendation of the state. Court hereby defers a finding of guilt, places Mr. Lopez on 4 years community supervision on the charge of evading arrest or detention with a vehicle, assesses a $1,500 fine, $290 court cost, $35 in reimbursement fees. The court dismisses under section 1245 reckless driving, DA 2022-1415 and DA 2022-1417, unlawful carrying of a weapon. And the court hereby orders the forfeiture of the weapon, a 9mm serial number as indicated on the order of deferred adjudication. All right, Mr. Lopez, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez, and then after that, you'll speak with the probation officers over here through this door, okay? Come on, come forward up here, please.
Good morning, Your Honor.
Good morning, Maria. How are you?
I'm doing very well, thank you.
Well, good morning, good morning. Got an issue here. Mr. Ivan Molina Hernandez does not appear to be in the courtroom. So, and his
Oh.
attorney's not heard from him. I'm not sure what the issue is. So.
Okay. Would you
don't-
like for us to reschedule it for later this afternoon, or would the court like to do that?
How long did I have
On
you
the
scheduled for this morning?
Half an hour, excuse me. Yes, half an hour from 9:15 to 9:45. Should I stand by for a while?
Yes, ma'am. If you would do that, if you would just stand by and we'll give it another 15, 20 minutes and then we'll make a judgment call then.
Excellent. I'll be standing by. Thank you.
Thank you, Maria. I appreciate it.
You're welcome.
Mr. Wells, are you ready?
Yeah.
Yes.
I'm ready. Oh, wait,
William Hayes, if you'll come forward. This is cause number CR 22-381. I'm sorry. Strike that. CR 22-300, 301, 302, 303, 304, 305, and 306. And I show that we're set for docket call today. Go ahead, Mr. Wells.
Yeah, Judge, I was recently, I was co-counsel to work with a few other lawyers on this case, and I would just ask the court for another docket call or the district attorney to see if we can get this case worked out and resolved without having to get on the trial.
Okay, let me check my notes here. I couldn't remember if I told them that this was their last docket call or not. Let me take a moment, look at my notes here. Yeah, I had notated at the last docket call that this would be our final docket call, and I told that to Mr. Wyatt. He said he understood, so. Is there a reason that we have to pass this hearing? Is there something going on? Is it just, is it a lack of pretrial? Is there a pretrial issue? And I think, because this is our 1, 2, 3, 4, this is our 6th docket call. He's been on.
The reason is for me to provide the district attorneys clarification of some of the information they received from some of their sources that are not law enforcement, and to talk to some of the law enforcement involved so that we can see if we can come to a resolution with that. You haven't said it on the drive.
And when were you retained? When did Mr.
Well,
Hayes?
and yesterday, today was actually, I looked at you probably 10 days ago, something like that, but the red letter got 2 gallons yesterday.
Okay. All right. I can reset to July 11th or July 13th.
11 or 13. That's just 3 weeks.
I understand, but I told Mr. Wyatt. I told Mr. Wyatt on May 9th that this would be the last one. So I gave him 45 days then, and he told me he understood. So I feel like this should have been handled beforehand. So I feel like I'm doing Mr. Hayes a favor here by not just saying no deal and set it on the jury trial docket. So.
Well, then we'll just set it for the 13th. We'll see what we can get done in 3 weeks. Would you like 9 a.m.?
Yes, sir. If they have a lawyer, the lawyers know to grab those. It's when they don't have a lawyer that we'll have to fill them out. All right, Mr. Hayes, once you sign and get your notice of appearance, we'll see you back on July 13th and you're free to go. Thank you, Mr. Wells. Mr. Biggs, are you ready? Gregory Horton, CR 2399. Just come on forward and you go right across that first row there. All right, Mr. Horton is set for pretrial today, Mr. Biggs.
Your Honor, I know that the court's standing order I'm not supposed to file, the kind of standard pre-trial motion, which I haven't done in this case except for a discovery motion, because there are numerous discovery issues in the case. There was a miscommunication between my office and the DA's office. Mr. Woodward had left. I didn't realize that. That's in my memo after receiving discovery, itemizing all the things that we felt like were missing based on the discovery that was provided. Since then, we've identified additional material that we think should be included. On that, I've had several conversations about it. Some of that information has been supplemented. A large portion of it has not. So I've got a discovery motion on file for that purpose, Judge. I also filed a motion to suppress. We're going to need to do that material on that, and we asked for a trial setting for it.
Okay. Are you ready to have the pretrial or the motion to suppress scheduled and heard on suppression?
And I'd actually issued subpoenas for that today, and I was confused about the court's handling of those types of matters. I understand the court's going to give me a date for a contested motion to suppress.
Correct.
We're ready for that at the court's convenience.
Okay. All right, the court will set Mr. Horton on the motion to suppress. And you said that has been filed and served on the state?
Yeah.
Okay. We'll set that for hearing on Tuesday, July 25th. Okay, thank you, Mr. Biggs. I appreciate that. Yes, sir, that'd be 9 AM. All right, Mr. Horton, once you sign and get your yellow copy, you're free to go. Sure. Yes, you may. Mr. Wood, are you ready, sir? All right, Benjamin Miles, CR 22-381. All right, Mr. Miles, I see that you're set to enter a plea today. Is that correct? All right, Mr. Miles, if you'll raise your right hand, I'm going to place you under oath. Mr. Miles, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? You can lower your hand, just speak up loudly and clearly for me. Your name is Benjamin Ray Miles, correct? And you can put your hand down. Mr. Miles, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jeff Wood. Are you pleased with Mr. Wood and the work he's done for you? Do you feel like you've had enough time to talk with him about your case and that you've had all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and assigned today that you do not understand? Mr. Wood, do you believe Mr. Miles to be competent today?
I do.
And you've explained to him his rights as they pertain to this case?
I have.
And you've also explained to him the advantages and disadvantages of a deferred adjudication plea?
I have.
And you believe that he understands everything that you've told him and that he's entering into this agreement intentionally, knowingly, and voluntarily? All right, Mr. Miles, it appears that you were charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 1 between 4 grams and 200 grams. A second-degree felony in the state of Texas has a range of punishment of not less than 2 years in prison or more than 20 years in prison, and also a possible fine not to exceed $10,000. The plea agreement in your case appears to be that you would plead guilty to that crime in exchange for the state's recommendation that a finding of guilt be deferred. That means that the court would consider the case today, and if there was sufficient evidence, the court would take that into consideration, would not convict you, but would rather place you on community supervision for 5 years, would assess a $1,500 fine plus restitution, court costs, and reimbursement fees. Do you understand that plea agreement?
Yes.
And that's what you're asking the court to approve today? And you understand also that if I do approve this agreement and place you on community supervision, if during those 5 years you violate any of the terms and conditions that you've read over today, the state could file a motion to adjudicate your guilt, ask the court to conduct a hearing. And if the court finds based on the evidence that you have violated your conditions of community supervision, the court could do a number of things, including adjudicating your guilt, convicting you of that offense, revoking your community supervision, and assessing your punishment anywhere from the minimum 2 years all the way up to the maximum 20 years. So it's pretty serious. You understand that? Understanding all of those things, you still wish to go forward? All right. Mr. Miles, how do you plead to possession of a controlled substance in penalty group 1 greater than 4 grams, less than 200 grams? Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason? Do you have questions about that? Okay. Has anyone threatened you, forced you, pressured you to make you feel like you had to plead guilty today? All right, the court will accept the defendant's plea of guilt at this time. Mr. Wood, any objection to the state's evidence supporting the plea?
No.
All right, there being no objection, states 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No.
From the defense? All right, court will review the evidence. Well, I failed to recognize this. He was originally indicted with a first-degree felony, but it's being pled to a lesser included second-degree felony.
That is correct.
All right, so I think I said that you were indicted for a second degree, when in fact you were indicted for a first degree, 5 to 99 or life, but you're pleading to a lesser offense, a second degree felony, 2 to 20. Okay. All right, the court has reviewed the evidence, finds that there is enough evidence to convict Mr. Miles of this offense. The court will follow the plea agreement and the recommendation of the state. Court hereby defers the finding of guilt on the lesser included second-degree felony offense of possession of a controlled substance, penalty group 1, greater than 4 grams, less than 200 grams. The court places Mr. Miles on 5 years community supervision, orders him to pay a $1,500 fine, $180 restitution, $290 court cost, and $35 reimbursement fees. Mr. Wood, you don't have the probation conditions, do you?
I don't,
Do we have probation conditions? Miles, Benjamin Miles. Tell you what, Mr. Miles, just have a seat. We'll call you back up in just a second, okay? Here, do you want those? Hold on to those and then bring those back to me. I'll bring them back up so we can go over those conditions.
Your Honor, may the interpreter address the court?
Yes, ma'am.
Excuse
Go ahead,
me.
Maria.
Thank you, Your Honor. It seems that it's almost time for me to leave Your Honor's court since the gentleman didn't come and I do have another commitment at 9:45.
Yes, ma'am. I don't believe that he has arrived, nor do I believe he will. So you're. Yeah, we just called again. He's not here. So thank you for being
Good.
here. Sorry for the inconvenience.
No inconvenience at all, Your Honor. May I be excused?
Yes, thank you, Maria.
Thank you
Yes.
very much and take care. Bye.
Mr. Adams, are you ready? Leon Baker. Just Leon Baker. Mr. Baker, if you'll come forward, CR 21-350 for pretrial. Go ahead, Mr. Adams.
Good morning.
Good morning.
Just that, they would follow us. Keep that down, set, okay.
All right, court will set the motion to suppress for hearing on Tuesday, July 25th. That'll be at 9 a.m. Mr. Baker, I'm going to need you to report to my pretrial release officers. I don't believe that you've signed conditions of pretrial release yet. You've posted bail in this case with easy pickings bail bonds. The court has conditions of pretrial release for all individuals indicted in this court. And so the conditions are going to be given to you. You're going to read over them. Mr. Adams can answer any questions that you have about those. These conditions are going to have several things, including reporting, paying a supervision fee, drug testing, doing all of these things to make sure that you're compliant with the law while you're pending resolution of this case. Okay, so you'll sign your notice of appearance there, get the yellow copy, and then come over here and meet with the pretrial release officers. They'll go over everything with you, have you sign. They'll give you a copy. Here's what you really need to focus on. If you violate any of the terms of these pretrial release conditions, then the court could revoke your bail, find it to be insufficient, put you back in jail until your case is resolved. Okay.
I think that's all I have to one.
Yes, thank you, Mr. Evans. Yes, sir. All right, Mr. Miles, step up. Thanks, Jeff. Sorry about that. All right, we're back on the record, cause number CR 22-381 with Mr. Benjamin Ray Miles. Mr. Miles, you've had an opportunity to review the conditions of probation, is that correct? And you've read over those and you've had Mr. Wood to answer any questions about those, is that correct? Now, you just read over those after you pled guilty to the offense. Does reading these conditions of community supervision cause you to change your mind about pleading guilty to the offense of possession of a controlled substance? So you understand all of these conditions, you understand that if you violate these conditions, when I was talking to you earlier about the state could bring you back, we could have a hearing, and the court could, if it finds that you violated any of the conditions I'm talking about are the ones that you've just signed. And you didn't have the benefit of understanding those before we went through that process. Now that you've had an opportunity to read all of them, you've talked to Mr. Wood about them, is there anything that concerns you about your plea agreement after the fact? Okay, all right, Mr. Miles, then do we have the judgment and all that stuff? All right, Mr. Miles, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez, and then after that, you'll speak with the probation officers over here, okay? Thank you, Mr. Wood. Do you have anything this afternoon?
No, well,
Be safe when you drive back. Hey, can you approach? Kirkland Huggins, CR 2125. Or Mr. Huggins, who did you hire? What attorney did you hire? I don't know that Mr. Green is in active practice right now. I don't know how long that's going to be. Ms. Curry, can you approach? Mr. Dancer, CR 22-63. All right, Mr. Dancer, you've spoken with Mr. Schmidt, correct? You understand that there's a legal issue regarding your status on probation. Is that correct? So what I'm going to do, Mr. Dancer, is I'm just going to reset you to be back before the court on August 8th at 9 a.m. Mr. Schmidt, Ms. Curry, and myself, we're going to be working on some legal issues between now and then. All I'm going to tell you right now, the issue is significant enough that you're not on probation at this time. Okay, so you don't have to report. All those conditions of community supervision are not applying to you at this time. However, before you leave, I am going to place conditions of pretrial release on you. You were on conditions of pretrial release in your case previously. You're reporting to Mr. Waddell, right? You're familiar with those things. I'm going to sign new ones today, so you need to stick around to get those before you leave, okay? And then once you get those, then you're free to go, and we'll see you back on August 8th. Mr. Schmidt, are you ready?
And
Who would you like first?
you can
Amy Van Treese, CR 2379. Come on up. So she's set for pretrial.
there's, I'm not the security, you want to be doing that.
Any objection from the state? All right, court will reset Miss Van Treese for pretrial on August 8th. That is your next date back, correct, Mr. Schmidt? It is now, okay. Well, is that what we were setting you for? Because you had vacation issues in July, so we were, that is Tuesday. I was pretty sure it was the first one back. Free to go. Brad Brewer. CR 23-6. Mr. Brewer is set for docket call.
Correct, that's very right, we're pretty close to resolution, we're taking another look at some of the potential execution routes. Pretty close to the moment.
All right, court will reset Mr. Brewer for an additional docket call August 8th at 9 a.m. Once you sign and get the notice, you're free to go. Newton,
Um,
Shauna Newton, CR 2363. Ms. Newton, come on up. Ms. Newton is set for pretrial.
That's very good. Once again, Mr. Right, there's, fairness, evidence of the student, it's the rating. Friendly, mentioned that.
Ms. Curry, do you believe August 8th is enough time if it's pending forensic analysis? Is it pending it or has it already been done or not enough time?
I'm aware of the king that the item is with the secret service. It's low on their other. Examinations. We're making some efforts to try to. Right now, it's pretty low.
All right, we're going to reset Ms. Newton then for Tuesday, September 19th. Ms. Newton, remember you're on conditions of pretrial release, so you need to be checking in. Just because you're not coming to court in August, you need to make sure that you're checking in with your probation, your pretrial release officer. Okay, all right, you're free to go. Mr. Crump.
I mark that out so there'd be no confusion about him being on bail because they've already been discharged and he's been on probation.
This is CR 23-46, State versus Wayne Robert Crump. Exact announcement for the other defendant.
It's also. Maybe connecting. Going to both of them. I don't see a conflict at this point, but that may change. And then what that means is, as of right now, he's asking September 19th for a pre-trial.
All right, court will reset Mr. Crump for pretrial September 19th at 9 a.m. Free to go. Who's next? Robert Bates. CR 2325. Mr. Bates is set for docket call.
Correct. Is, got the PSI stuff, well aware, but we have to stay for the significant PSI.
All right, court will set Mr. Bates for plea on August 8th. Who's next, Mr. Schmidt? Shelby Hood. So CR 23-54 and CR 23-55. Ms. Hood is set for pretrial. All right, court will set Ms. Hood for plea on August 8th. And the court will order a PSI. Try the one. Ms. Curry, will this, Ms. Hood, will that be a short form or a long form PSI? Short form. Jacob Wyatt Myers, CR 23-30. Mr. Myers is set for docket call. Let's set Mr. Myers for August 22nd. It's a Tuesday. That'll be a short PSI or a long? Third degree assault. Bill. Oh, he didn't know. They may be in Denton County. Possibly maybe in the county. What is that? Yes, this is. That was a short one PSI, and I moved it to the 22nd. Who's next? Hey, we'll have to talk about it. All right, CR 11-119, State versus Jeremy Wayne Estridge. I think we have this set on status.
Correct, previously, Mr. Esmond has been on probation for quite some time with the restitution amount in this case. And it's at $100,000. It's about half the way through the restitution. I think you see that getting close to expiring or was. The goal was to come up with a lump sum. Mr. Esmond to complete those restitution payments for the government. It looks like, based on my discussion, Mr. Esmond, that lump sum option that we were hoping for was likely to fall through. So we're likely to have to shift gears. So previously we had set it out 3 months at a time. You know, obviously we still want to resolve it. But I don't know if the court wants to try to set out 3 months at a time in the hopes for a long time. That's probably not going to happen. So what we'll need to do is we sit down with these on switch gears on them. I think at one point we the line of the this one that's
Court will set Mr. Estridge then for hearing on, we'll set it August 8th, so that you'll have time to talk with the state and shift your gears. And then if there's no resolution, then we'll set it, we're gonna also set it today for August 24th for contested hearing. Mr. Schmidt, Ms. Curry, can you approach? All right, Mr. Schmidt, who's next? Lisa Holden, CR 23-53. Show this our first setting on pretrial. All right, court will set Ms. Holdren for docket call on August 8th at 9 a.m. Once she gets her notice, she's free to go. Who's next, Mr. Schmidt? Daniel Lee Wolverton, CR 23-84. So this is Mr. Wolverton's first setting on pretrial. All right, court sets Mr. Wolverton for docket call on August 8th, 9 a.m. And once he gets his notice, he's free to go. Who's next? Robert Michael Wells, CR 17-266. This is a hearing on motion to revoke. Go ahead, Mr. Schmidt.
Correct. Mr. Williams. Well, let's start today. First time we got the benefits. States the motion, there are a couple of allegations that I think will be able to resolve. We're gonna ask the commission to all the site and give us an opportunity to get that information.
All right, court will set Mr. Wells for hearing on motion to revoke on August 8th. And we'll simultaneously set it for contested hearing on the 24th. If there's no resolution reached. The 24th of August. John Earl. I'm sorry, Sean Clay Earl, CR 2350. First setting on pretrial. All right, court will set Mr. Earl for docket call on August 8th, 9 AM. And once he gets his notice, he's free to go. Jessica Swindle, CR 23-19. Show this to be the first setting on docket call.
That's pretty good.
Any objection from state?
Yeah.
All right, court sets Ms. Swindle for an additional docket call August 8th at 9 AM. Do this. This calls the Corey and Fulbright CR 22-214. Courts received information that Mr. Fulbright is showing to be in custody in Denton County. So the court will reset Mr. Fulbright for pretrial on August 8th and status of custody. And then have you heard any additional information from Ivan Molina Hernandez?
I think, you know, I used to say it didn't come off. I'm not sure if you did or didn't understand. But I think they got that, so we'll check and see what's going on.
Okay. All right, let me know when you're ready, Mr. O'Hagan. And then I did this one. Okay. Jaime Zarate, CR 2278. All right, Mr. Zarate, this is a hearing on status of attorney. Have you hired a lawyer? And why not? How are you on bond right now? How are you out of jail right now? Okay, so you paid a bondsman. Yeah, so you paid someone to get you out of jail. But you haven't paid a lawyer to represent you to resolve your case.
Well, I haven't been my.
So what's your plan? Do you just want me to keep resetting your case? And then if you never get a lawyer, the case never gets resolved? You're gonna represent yourself? You think that's a good idea? So you don't have any means to hire an attorney. You don't have a job. You don't make money.
Well,
You don't have assets that you can get a loan on. You don't have assets. Do you own a car?
No.
You own any kind of vehicle?
No.
Okay, do you have You have any cash? You have a bank account?
No, I,
How much money do you have in the bank?
right now, like,
Okay. And you have four-wheelers, boats, guns, anything?
no,
Okay. So you borrowed money from your uncle, he bailed you out of jail. And you haven't paid him back. And you want to represent yourself. You said you've talked to Nolan White and Jeff White?
I talked to the Secretary of Nolan White, I talked to Jeff White. I was out for work, so I couldn't make this appointment. But, during the phone, he was telling me that upfront, I was gonna be $2,500 and not some appointment part. So I just, I just assumed it was over.
On the application that you filed with the court regarding your assets and need, you indicate that you bring home close to 4,000 a month and you only spend 1,600 a month. So that's 1,400. And actually, no, that's more than that. That's what, 2,400.
There's probably a mistake around it, but from what I have, I doubt that's what
I mean, didn't you fill this out?
yes, sir.
You said your take-home pay was 2,000. Your wife's was 1,800. So that's 2,800. And then you put with your rent, your utilities, your food, your transportation costs, your cell phone, probation fees, credit card. And so that's how courts like me figure out whether or not you're entitled to a court-appointed lawyer. And so by this, you should be able to save up enough money by cutting other expenses in your household and still have enough money to provide for your basic needs.
Yeah, Your Honor, I'm not sitting there on John, but for some reason I just don't have that left over.
All right, have a seat. I'm gonna have some paperwork brought to you about representing yourself. I can't access anything from here. I don't have any connection to IT from here. Are you ready? Mr. Ojeda, you say? Ojeda. All right, this is cause number CR 23-115, State of Texas versus Nathan Stephen Ojeda. Court has found Mr. Ojeda to be indigent has appointed the Honorable Richard Schmidt for purposes of counsel. Mr. Schmidt, have you had an opportunity to review the indictment with Mr. Ojeda?
I have, I was in review that, please go to today's statements, so. You can't start doing one of the-
All right, court will find that Mr. Ojeda has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record, and the court sets Mr. Ojeda for pretrial hearing on August 8th.
Actually, could I, ask the board to get the thing with the, not too much later, think about it. Taking more than-
All right, court will set Mr. Ojeda for August 22nd.
Thank you.
And Mr. Ojeda will need to sign conditions of pretrial release after he signs his notice. Hmm. 22nd. I said 22nd, correct?
He did.
Okay. All right, this is cause number CR 21-398, CR 22-51. State versus Royce, Latate White. Mr. White, you were set to enter a plea today. Your attorney filed a motion for continuance after hours yesterday, which the court really hasn't even had time to review. I did look at it. He just says he can't be here today. I think Ms. Curry has some more information on that. Mr. Herring is the one that was here in court last time when we set this date, so I'm not happy with him not being here, right? You're here, I'm not gonna hold your bail insufficient, but I'm gonna tell you, I'm not happy with your lawyer right now. And he's wanting to reset it for 30 days. I'm not gonna do that. I'm gonna reset this for July 6th. If he can't be here on July 6th, then you need to get another lawyer. Okay? You understand what I'm telling you? You haven't done anything wrong. I want to be clear about that. But your lawyer's putting you in bad light with the court, not showing up when he's supposed to show up, filing motions after 5 o'clock, not appearing today. Usually you file a motion for continuance, you come to the court, you get a hearing on it. And I grant it or I deny it. You don't just file it and not show up. That's why you were instructed to be here today. Okay. So you've complied and you've done what you're supposed to. So I'm not going to punish you for your lawyer's deeds. But you need to relay that message that I'm not happy with your lawyer. Okay. So he needs to be here on July 6th. If he tells you he can't be here, then you need to get another lawyer and be here on July 6th so we can enter this plea or resolve the case in whatever way you and the state are going to resolve. Okay. All right. So I'm going to have you sign this reset notice for July 6th. It'll be at 9 a.m. that morning. And once you get that, you'll have a copy, you're free to go. You need him. Mr. White, hang on just a second. Let's just keep it in the morning. Let's just keep it in the morning. You're still good. We'll see you at 9 o'clock on July 6th. Christian Grindell. This is a sanctions court hearing. All right, this is a sanctions court hearing, CR 19-177, State versus Christian Grindell. Christian, the last time you were in court, you were ordered to do a couple of things. One, pay $60 to probation. I see that you complied with that. Other was to work 25 hours community service because that's what you're really severely delinquent on and what we're trying to get you caught up on. It says that you failed to comply with that. Did you work any hours of community service?
At the end of May, I was out of work for about 2.5 days. I got a little bit behind bill. I didn't get all of the stuff. So I didn't have a. And that's what I wasn't able to get the few hours. I did. And then my father and my son.
So what's your plan on on getting your community service work?
I'm gonna be, instead of 10 hours, I'm gonna have, in- I'm gonna be-
I mean, what's your plan on? How many hours are you planning on doing and when are you gonna do them and where are you gonna do them and how are you gonna get caught up? And how many hours are you getting at a time?
Last time, the last time I 10 hours, we have like 42 hours. I've been trying to get at least a few weeks to, turn in, but, I can think it's 45.
All right, I'm gonna do this. I'm gonna bring you back on August 8th. And I'm gonna order you to do two things. Pay probation, your $60. And you've got to have 25 hours turned in time so that it makes my report. Failure to do either one of those, there's gonna be 2 days in jail for each one. Okay, so if you only do half of it, you're gonna do 2 days in jail. You don't do either one of them, it'd be 4 days in jail. Okay. There. No, I'm not gonna go over it on the record. Yes, you're free to go. Kendrick Mitchell. All right, this is sanctions court hearing in CR 18272, State versus Kendrick Mitchell. Mr. Mitchell, is this your first time in sanctions court? Looks like you're on probation for evading arrest with a vehicle, a third-degree felony. You got a 6-year prison sentence on February 25th of 2020. No, I take that back. Yeah, you did. Yeah. So you're on probation with that prison sentence hanging over your head until February of 26. And I've got a note here that you tested positive for THC back in March and that you're delinquent on your probation fees. You understand both of those are grounds for the state to just file a motion to revoke and put you to a hearing and ask the court to put you in prison? You understand that? You understand that you have the opportunity as part of the sanctions court program to avoid that by being sanctioned today. You understand what that means? Means I'm trying to get your attention by setting goals for you and then punishing you if you don't reach those goals in hopes of avoiding a prison sentence, which means that you tested positive for THC and you haven't paid all your probation fees. Rather than revoking you, having a hearing and revoking you and putting you in prison, there's some sanctions that we can do. I can sanction you 1 day in jail. You have to go serve 1 day in jail for your positive test for THC. And I'm gonna order you to pay, you're gonna have to pay $160 towards your probation fees. And what we're trying to do is get you caught up so that you can stay current on probation, so that you can successfully complete probation and not end up in prison. So that's what we're trying to do here, okay? Yes, sir, go ahead. Are you like at the warehouse or something? Distribution? And so you, you're saying that you tested positive for THC from secondhand smoke? And they moved your position last month. We know if, has Mr. Mitchell ever tested positive for marijuana? Just this time.
He reports.
Come up here, Mr. Mitchell. Right. there. Who's your probation officer?
They just switched me this, this is my third one that I've had.
But you report in Kaufman County?
This. It's in Kaufman. I had, the first two I started with, then they switched me to, with this perk,
Why are you delinquent on your fees?
I've been trying to pay, but they won't let me pay online, so I just brought money today to take over there and pay today.
How much you gotta pay today?
I'm gonna pay 300. They're trying to get online to pay it, but it's not letting me pay.
What's the issue on that?
I don't know, they keep saying like, I owe behind like 14, so the amount they lose is 1,400, something like that, and they let me pay, so he said I can bring the money down here today and pay. I just tried to pay it like last week, they let me pay.
All right, I'll tell you what I'll do. I'm gonna take your word for it that you're not smoking.
Nah, I've been smoking, I've been doing good for the last 3 years, so like I said, I don't do no more break to go home.
I'm gonna take your word for it, so I'm not gonna give you the day in jail for the positive result. I want you to pay your 300 today over at the probation department. Can he pay over there, even though he's being super, can he get credit here? Can he pay here directly? He can't, okay.
And we'll find out what's going on.
I got on it, last Thursday.
It's technical stuff. Address doesn't, the address we have.
Yeah, I got the same, the code that I use, it's my code, it's the same.
We'll figure it out.
It's one level. I don't know. Take, so I just want money down here to pay the day. Get caught up and everything.
Well, let's do that. Let's go over there and get you caught up. What I'm gonna do is I'm gonna bring you back a few times, or I'm gonna drug test you today. And we're gonna monitor you. And if there's no, no THC in the next 2 or 3 times, as long as you're getting caught up, then I'll just put you back on your regular probation. Okay.
She just text me on Friday when I meet.
You Kaufman are here. Kaufman, okay. Well, we'll do it. Let's just do a field test today and then, let me see. Yeah, let me see that. Rachel, if he pays 300 today, is that? This is not a month, I'm assuming. I want to be able to tell him what he needs to pay a month. Do you know,
I can look that up.
see what he's delinquent?
I'm trying to pay like every other week. at least $100 so I can get covered.
Yeah, will you just check with me?
She text me, she text me like every other month. So, like I'm here to say, dude, it's not just one. Automatic leave the next month. The next month, so like I told her, so it definitely never a month, it's still showing. So,
Well, it'll take a while.
well, that's why I kept explaining to her, but she don't go. I mean,
Well, what we'll do is we'll do a urine test today and then that'll help us see like potential levels. We could always send that off or to see levels, if it's high, low, all that good stuff.
I think she said I had the court date on May 11th, and I never did receive the letter in the mail that I had a court date. And that's why I was telling her, like, she never would tell me until after the fact that I had a court date.
Court date here.
Yeah, that's what she told me. Well, she called probation, and I knew I talked to her on the phone.
Where do you live at?
I'm staying too.
Here.
There's the one for.
You said you were gonna pay, how many months does he need to do that?
Unless he gets this now.
Okay. So how much were you gonna pay today?
About 300.
All right, so this is what we're gonna do. So you pay your 300 today, and then next month. It'll be 114. What 114 is what you need to pay a month until you expire from probation. That will get you caught up. Okay, so pay your 300 today, and then for your July payment needs to be 114. Your August payment needs to be 114. I'm gonna bring you back on August 8th. Okay. August 8th, and then we're gonna, like I said, we'll do the UA. Let's do the UA today, and then we'll kind of see what the level is. And then, as Officer Matura said, that they can help you figure out the payment issues. Sign right there on that X. You got a pin on there?
You said levels.
Well, that's, I want to get a baseline. I want to see, because if it comes back and it's high, then we'll have a problem next time.
Okay.
All right, I'm gonna give you this as well. Can you have that? That shows your payments, delinquencies, all that good stuff, okay? All right, did we kept the white one? All right, come over here and see Officer Matura, and then we'll see you back in August.
Did all this get filed? All this plea, all these things. Just need to be filed. All these things get filed. And then she can get a copy of them, or vice versa. I need to make sure they're in the record so I can go back and look at them. Do you want to file those, or do you want those to be filed and then come to you? Okay, she said she'll do it. She'll make a copy. I just want to make sure that it gets filed, so it's on the record. What date did I get him? 8th. I get him. I did.
You need something. Yeah, he's gonna represent himself on a misdemeanor, so I'm gonna let him stay and work it out. Yeah, okay, we'll see what Tana wants to do, because the motion's been filed, so. Because it's not a sanctions court, it's a motion. Mr. McElroy. Just come right, you can move those chairs if you need, just have him well right over there. You can slide that, one of those out of the way. All right, this is cause number CR 14145, State versus Randy Lee Shane McElroy. Mr. McElroy, the probation department, as you're aware, has filed a motion to revoke. The court finds you to be indigent at this time. The court's going to appoint an attorney to represent you. Ms. Taberham is making that appointment as we speak. She's going to bring you some paperwork. The attorney that's being appointed is not here today. She'll have that information for you. There is a warrant for your arrest on this case because you previously were in jail and I gave you a personal bond. And then I set you for court and then you didn't appear for court. And so you have another warrant. What I'm going to do is I'm going to give you another personal bond. Okay. And I'm going to have you go out to the jail and then you need to book in and book out on that personal bond. And I'm going to reset you today. Okay. But we can't continue in a revolving door of you going to jail, me giving you a personal bond, and then showing my court. Okay. If you do that again, the next time I'm just going to take you in custody and I'll just keep you in the jail where I know you're at.
Yes.
Okay. I'm gonna have you come back on August 8th. And I'm gonna have a form for you to sign, and then I'm gonna give you a copy of it. All right. Deputy Martinez is going to bring you this form. I need you to sign where it says defendant. And then we're gonna give you a yellow copy, and then I'm gonna see you back on August 8th. And then I need you to stay in the hallway, okay? Stay in the hallway so that Ms. Taberham can bring you two things: the order appointing the attorney, and then an order saying that you have a personal bond. But when you leave here, you need to go right to the sheriff's office, allow them to book you in on that warrant. If you don't do that, then you're gonna have an active warrant for your arrest. And they're gonna pick you up on a traffic stop or come pick you up at the house or whatever. So you need to go out there and get it taken care of so you're not in the system. You understand?
Yes, sir.
Okay. So we're gonna give you that yellow copy, have a seat in the hallway, and Ms. Taberham will bring that paperwork to you in just a moment.
Yes, sir.
You're welcome. All right, Mr. Zarate. All right, Mr. Zarate, with regard to your request to represent yourself, court finds that you are on a motion to revoke for a Class A misdemeanor offense of assault. I believe family violence. Let me double check that. All right, Mr. Zarate, it appears to the court that on August 10th of 2021, you appeared before the court. You pled guilty to a Class A misdemeanor offense of assault causes bodily injury. You were represented by Mr. Nolan White at that time. The court heard the plea agreement. The court allowed you to plead guilty to the lesser included offense of assault causes bodily injury. The court assessed your punishment at deferred a finding of guilt and placed you on 2 years of community supervision, ordered you to pay restitution of $5,808.38 plus court costs and reimbursements. And it was during that period of your community supervision that the state of Texas has filed its motion to revoke. The potential range of punishment that you're facing for a Class A misdemeanor is confinement in the Van Zandt County Jail up to a maximum 365 days or 1 year. You've requested to represent yourself on this matter. So at this time, I need to ask you a series of questions. If you'll raise your right hand, I'm going to place you under oath. Mr. Zarate, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right. Your name is Jaime Zarate Jr., is that correct? And Mr. Zarate, you are the same Jaime Zarate Jr. that's currently on probation in this court.
Yes, sir.
All right, Mr. Zarate, you and I have had discussions during this proceeding about hiring an attorney. You've indicated that you do not have the means to hire an attorney. I've indicated to you that the application you submitted shows the court that you do not meet the financial criteria necessary for a court-appointed attorney, and you have indicated that you would like to represent yourself. You do have a constitutional right to represent yourself. However, before I can allow that, I do have to know some background information about you. So the questions I'm about to ask you are designed to inform the court as to your age, background, education, and experience, including legal experience, and then to admonish you about the dangers of self-representation, and also to admonish you about the technical rules of evidence and procedure that you won't be given special consideration, things of that nature. You understand that?
Yes, sir.
All right. So tell me, Mr. Zarate, how old are you?
24 years old.
24. And what is your highest level of education?
High school diploma.
And what kind of work do you do?
Construction.
What type of construction specifically?
Oh, carport building. Work for Carolina.
Have you had any experience representing yourself on other criminal matters and or civil matters? Do you understand what the court has told you regarding the range of punishment for this case?
Yes.
And tell me again what it is I've told you.
Okay, well, representing yourself is risky.
And why so? Why is it risky?
Well, because of educational purposes, or reasons that, you know, most likely not as educated, to some word, no basic, to higher level of law. know, where is that? So I want to understand.
And you understand that that disadvantage is also that you're not familiar with the rules of evidence, the rules of procedure. You understand that? You understand that although you are not experienced in legal education or representing yourself in other matters, that you would not be afforded special consideration because of that. That means that the court would not waive the rules of evidence for you to allow you to do things that attorneys are not allowed to do. And so you understand that the court is not here to assist you in your defense. You understand that the court is not here to assist you in granting you admission of evidence. And the court's not here to assist you in educating you on what the rules of procedure are, meaning I can't tell you how to do things, when to do things, why to do things, or how to do things. You understand that the state of Texas will be led by an attorney with not only college experience, but legal experience, and has been rigorously tested by the state for admission to practice law. And they have the requisite knowledge regarding rules of procedure and rules of evidence. And not only that, they have years of experience in articulating and arguing that in courts of law. Understanding all of those things, do you still wish to represent yourself?
There's doubts, but, I think, I really don't get off the board.
All right, at this time, Mr. Zarate, are you waiving your right to counsel and representing that you are unable to afford an attorney, and that you are not indigent for court-appointed attorney, and that you're giving up your right to counsel and asking that you be allowed to represent yourself without an attorney? All right. The court finds that Mr. Zarate, as a 24-year-old man, is of sufficient age and background, however, that he lacks the education to understand the nuances of the rules of evidence and procedure, is educated to understand the implications and dangers of self-representation. Court has informed him of the nature of the offense and the possible penalties if he is convicted and sentenced of the offense. That he's been advised that the technical rules of evidence and procedure will be administered, and he will be obligated to comply with those, and that he will not be given special consideration because of his lack of legal training or legal experience. And furthermore, that he will not be allowed to obstruct the orderly procedure of the court or interfere with the fair administration of justice. So the court hereby grants the waiver of counsel and allows Mr. Zarate to proceed with self-representation on the Class A misdemeanor offense of assault causes bodily injury. Mr. Zarate, here's a form here. I want you to, it's basically, I've just read through this form and asked you these questions. I want you to take a moment to read it. If you have any questions, you let me know. If you do not, then you're going to sign where it says defendant, and you're going to date it. Any questions, Mr. Zarate? Okay. All right, court orders that the defendant's request to waive counsel is granted. So what this also allows, Mr. Zarate, is it allows the prosecutors here to be able to talk to you directly about your case. Okay, so Ms. Curry, I have signed the Beretta warnings. I get you a copy of those. We file those, get a copy for the state, and then got about 20 minutes before the court concludes this morning docket. If y'all want to talk today, we don't have to reach a resolution today. Court can reset, or I can reset now and give y'all time to talk between now and the next setting.
Judge, why don't you put us on the next, test docket? And then, between now and then we can try to wait for the.
I like that plan. All right, Mr. Zarate, I'm gonna have you sign this notice of appearance. It's gonna direct you to be back on July 25th. That's our next contested docket. What that means is that you and the state don't resolve your case by some kind of agreement. Then on the 25th, we'll have a contested hearing in which the state will be allowed to give their evidence. You'll be able to cross-examine their evidence. You'll be able to produce any evidence that you want, okay? Have you sign that, and then we'll give you a copy of it and you'll be free to go. All right, we need to call the names Michael Bowman, Molina. Yeah, that's it. You'll call those two names loudly, distinctly 3 times in the courthouse. All right, the court has called Michael Dwayne Bowman at 9 a.m. He was not present. Court has also called Ivan Molina Hernandez at 9 o'clock. As previously said, Mr. Molina was not present either. Court has had their names called loudly, distinctly 3 times in the courthouse with no response. It's approximately 11:41 a.m. Court hereby orders judgment not size of alias capias in each case. And the court will stand in recess until 1:30.